Welcome back to the Constitutional Clarion. The threat made by some members of a Commonwealth Parliamentary Committee to convict a CEO of a supermarket chain for contempt of Parliament and to jail or fine him has prompted people to ask, well, can a House or Committee of Parliament actually do this? One thing that we've learned from recent controversies about immigration detention and preventative detention is that criminal conviction and punishment of people is exclusively a judicial power. According to the constitutional doctrine of the separation of powers, only the courts can do this. So how could a House of Parliament do it? Surely this would breach the separation of powers, you ask. Good question. Now the answer to that is that the punishment of contempt of Parliament is an anomalous exception based upon history. If you trace back far enough to the Westminster Parliament in the United Kingdom, you find that it not only had legislative functions, but also judicial functions as the High Court of Parliament. There was no clear separation of powers in those days between the judiciary and judicial power and the legislature and legislative power. Each house of the Westminster Parliament became responsible for managing its own discipline to support its effective functioning and accordingly could exercise a power to judge and punish contempt of Parliament. But, you rightly say, the houses of the Australian parliaments were never courts. So how did they get these powers? The answer is that these houses were either had directly conferred upon them the same powers as the House of Commons held at some point or other, or they have inherent powers that are necessary to support their functions. The New South Wales Parliament, for example, falls into that latter category of inherent powers, and those powers do not extend to punishment. But other parliaments have powers that are tied to those that were able to be exercised by the House of Commons. Section 49 of the Commonwealth Constitution grants the Commonwealth Parliament the power to enact legislation that declares the powers, privileges and immunities of its houses, their members and their committees, but then it goes on to say that until those powers, etc., are declared by Parliament, they shall be those of the Commons House of Parliament of the United Kingdom and of its members and committees at the establishment of the Commonwealth. Now, in the absence of Commonwealth legislation that says otherwise, each House of the Commonwealth Parliament therefore has the same powers that the House of Commons had at the time of Federation in 1901. Now, to find out what they are, you need to look at the most relevant edition of Erskine May, which is the sort of the parliamentary Bible, which tells you everything that the Houses of Parliament could do, which is, by the way, the 10th edition from 1893, which I do have a copy of here, and I am very pleased to have got hold of it because these are quite useful and valuable in Australia. Probably not so much anyone cares about the 10th edition anywhere else, but for Australia, that's the last one before Federation. So that's the one that you need to look at to see what the powers of the houses were then. And the House of Commons then did have the power to imprison people for contempt of Parliament. And hence the houses of the Commonwealth Parliament inherited the same power because of Section 49 of the Constitution. Have those powers actually ever been used? Well, yes, but imprisonment has only occurred once at the Commonwealth level, and rather controversially. Now that happened in 1955, where a journalist and editor, Frank Browne, published an article in the Bankstown Observer, which was owned by Raymond Fitzpatrick, and the article made allegations about a member of Parliament having previously been involved in an immigration racket. The member concerned saw the article as an attempt to blackmail and intimidate him, and he referred it to the Committee of Privileges of the House for investigation and report. Both Fitzpatrick and Browne admitted that the purpose of the article was to keep the MP quiet on certain matters. The committee found that both men had published the allegations with the intent of influencing and intimidating a member in his conduct in the House and to discredit and silence him. It referred the matter to the House of Representatives to take appropriate action. Both men were given the opportunity to address the House, but not to be represented by legal counsel in doing so. Fitzpatrick decided to take the probably more sensible route of apologising, but Browne gave a speech which objected to being convicted by a House of Parliament without a fair trial, and he also spread around references to Adolf Hitler and the Star Chamber, etc., and attacked the process in a way which was not necessarily tactful in the circumstances. The Prime Minister, Robert Menzies, then moved that they both be committed to prison for 3 months, from the 10th of June to the 10th of September 1955. Some members objected that the House itself should not exercise such a power because there hadn't been a proper trial before a court and a jury. H.V. Evatt then moved an amendment seeking to instead fine the men. But because the House of Commons had not actually exercised a power to fine anyone since 1666, there was some doubt about whether or not the House of Commons still held that power in 1901, and therefore whether that power transferred over to the House of Representatives. The power to imprison, however, certainly existed. The amendment was lost, and Fitzpatrick and Browne were both brought before the House for the announcement of the judgment against them, that they were convicted for contempt of Parliament, and they were to be put into the custody of the Sergeant of Arms and imprisoned for 3 months. The problem, however, was that there actually was no federal prison to put people in. Indeed, Section 120 of the Constitution provides for persons who are convicted of offences against Commonwealth laws to be imprisoned in state prisons. But of course, that makes no provision for persons who have been found in contempt of Parliament. Old Parliament House did not have any appropriate prison cells, so Fitzpatrick and Browne were initially housed in the Police Watch House. As it didn't have any catering facilities, every evening the police would take Fitzpatrick and Browne out to the local pub for dinner. They later spent some time in Goulburn Jail as well. Now, by all reputes, Fitzpatrick was indeed a violent gangster and Browne was little better, so there wasn't actually very much sympathy for them personally, particularly upon MPs who had been abused by them previously. The press, however, was understandably highly critical about what had occurred. Newspapers pointed out that the men had not been permitted legal representation, they had not had a fair trial, they had no right of appeal, and these MPs were judges in their own cause without the benefit of any kind of independent jury. Unsurprisingly, a challenge was brought before the High Court. The court accepted that it had the power to judge whether a house has a power or a privilege. But if the House does have that power or privilege, the courts themselves cannot adjudicate upon how it's exercised. The warrant issued by the Speaker merely said that Fitzpatrick and Browne had been adjudged guilty of contempt. The court said that as the House had a power to adjudge people guilty of contempt, the court then could not go beyond the terms of that warrant. But if the warrant had specified the ground of commitment, the court would have been able to determine whether that ground was sufficient in law. In this case, the court refused to overturn the imprisonment of Fitzpatrick and Browne, and they served out their 3 months' imprisonment. After this controversy, however, there was little enthusiasm to take this course again. In 1987, the Commonwealth Parliamentary Privileges Act was passed. Section 6 abolished contempt by defamation, that is, contempt of Parliament by merely saying words that are defamatory or critical of Parliament or of a House, its committee or a member of Parliament. There's an exception, however, for contempt that's committed in the presence of a House or its committee, because this can be disruptive of the effectiveness of Parliament proceedings. Section 4 clarifies that conduct, including words, does not constitute an offence against a House unless it is intended or likely to amount to an improper interference with the free exercise by a House or committee of its authority or functions, or with the free performance by a member of the member's duties. This limitation would open up the possibility of judicial review if a person were committed for contempt in the future. Section 7 clarified what penalties a House could impose for a contempt. They include a fine of $5,000 for an individual or $25,000 for a corporation. As you can probably tell, it's not indexed with inflation, and that's why the amounts are so low. It also includes the penalty of imprisonment for a period not exceeding 6 months for contempts against the House. Section 9, finally, specifies that where a House imposes a penalty of imprisonment for an offence against the House, the resolution imposing the penalty and the warrant that's exercised by the presiding officer to commit the person to custody shall set out the particulars of the offence. Again, this is to permit a court to be able to undertake judicial review of whether the particular offence itself falls within the powers of the House. So, knowing all that now, let's ask ourselves, could the refusal of a supermarket CEO to answer the question of a parliamentary committee amount to a contempt of Parliament? Arguably, yes, to the extent that it amounts to an improper interference with the free exercise by a parliamentary committee of its inquisitorial functions. But would it be likely to lead to imprisonment? And the answer here is obviously no. No one has been imprisoned for contempt since Fitzpatrick and Browne, and the likelihood of imprisoning a person for refusing to answer a question about the commercial profitability of a corporation is about zip. At worst, there might be criticism of a person by the committee or a demand for an apology. Even a fine is unlikely, but at least now we know it is available because of the Parliamentary Privileges Act. Finally, are there cells below Parliament House that you can be imprisoned in? When I worked in Parliament House back in the 1990s, someone actually did show me a room which was full of old boxes that was in the bowels of the building underneath. And they said that it was originally designated as one of the cells to hold people in who'd committed contempt. But they were probably just making it up. Various senior officials in Parliament House have declared that there are actually no cells in the building, although apparently there originally was a plan to include some cells in Parliament House. Perhaps just the idea of it was intended to be an incentive not to commit contempt of Parliament. Frankly, it wouldn't be too hard to turn a room into a cell if it was needed, but realistically, I don't think this is going to happen. If I were the supermarket CEO, I wouldn't be too worried by all the sound and fury of the committee hearing, and I certainly wouldn't be packing my toothbrush yet in anticipation of committal. But I should point out it does remain important to be respectful of Parliament and its privileges and to cooperate with parliamentary committees and their inquiries because they are fulfilling an important function for the nation. And people should be mindful also that in some jurisdictions, for example in New South Wales, refusal to answer a lawful question of a parliamentary committee can also amount to a criminal offence. But as I said, in the circumstances, it seems to me very unlikely that a Commonwealth Parliamentary Committee and indeed the House itself would then take the extreme step of imprisoning a CEO for failing to answer such a question. Thank you for watching the Constitutional Clarion, and I look forward to seeing you next time. Goodbye.